Hello, everyone, and welcome to a new session with Rights and Responsibilities Awareness Initiative. Today, we are lucky to have Rachel Merucci from TBH Legal to talk to us about adult guardianship. Thank you, Rachel, for being here with us today.
Thank you, Haytham, for having me. I'm so excited to be here. Welcome, everyone, to Adult Guardianship Explained. We have a lot to cover in a short period of time, so I'm going to just jump right in. Before we begin, I do have to state my legal disclaimer. This presentation does not constitute as legal advice. It is legal education, and by participating today, you are not a client of TBH Legal, and there's no paralegal client relationship. My name is Rachel Merucci. I am a licensed paralegal in and for the province of Ontario. And today I'm going to take you through a number of different areas in regards to what adult guardianship is all about. We're going to start by talking about powers of attorney. We're going to get into adult guardianship, how it's different but similar to powers of attorney. How can I become a guardian? Which guardianship is right for me? Who can apply for guardianship of property? And then we should have a good amount of time at the end to get through any types of questions that you might have for me. Now, I'm not sure where you're logging in from tonight. We seem to be live streamed from a number of areas, but if you do have an option to chat, like some sort of chat or typing in option, please feel free to use that with any questions that you may have. And at the conclusion of the presentation, we will get to as many as we can. So let's get started. So why are you here today? Well, when we're dealing with adult guardianship exists because of mental incapacity. And there are two major causes of mental incapacity. Number one, developmental disabilities, which are usually present at birth or in early childhood, and it can range from mild to severe. And number two, conditions which were acquired later in life, like an accident or an illness like dementia. So where do you fit in this part? You're probably here tonight because you're either a parent of a teen or a young adult with a developmental disability, or you have a loved one that is an incapable adult who does not have a valid power of attorney. So if you're here today because you're a parent of a teen or a young adult with a developmental disability, well, you may have just learned that your parenting status changes when your child turns 18. And what that means is, in the eyes of the government, the child, regardless of their diagnosis, is seen as a fully functioning adult who is capable of making their own decisions unless proven otherwise. So that means they're recognized as an adult and they have all the rights and responsibilities of an adult. And that means things like literally on their 18th birthday, when they wake up, they have the ability to open a bank account. They can buy a car if they want to. They can make any type of personal decision for themselves because they have simply turned 18. So when your child turns 18, you as the parent are no longer their legal guardian. You no longer have legal standing as your child's legal representative. You can no longer make legally binding decisions on your child's behalf. You can no longer receive what would be considered private personal information, like disclosure about your child. And I put this last point in, even though it's not a legal point. Child funding and other programs which may have accommodated your child until their 18th birthday will not transition to adulthood. And that means your adult child must start completely fresh with no carryover of any kind. There is no ability to delay the date. There is no ability to change the date. They are simply no longer accommodated by these programs on their 18th birthday. Now, if you're here today because you have a loved one that's an incapable adult and they do not have a valid power of attorney, well, some challenges that an incapable adult may have are listed here. Now, some of these will also apply to the adult child category as well. So we're looking at things like they don't have a bank account or they forget how to use it. They're unable to submit their taxes without help. They're unable to apply for ODSP or the passport funding through the DSO. They're not able to contribute to their RDSP. They're not able to pay for support that they need, like PSWs. They may not be paying their utilities, and therefore they could be at risk for losing heat and water and all the other things that housing brings. They're vulnerable to financial exploitation from strangers or, sadly, even other relatives. They're overspending, they're underspending because they may not comprehend how to budget anymore. And they're not able to arrange maintenance on their home, or if they are, they don't remember how to pay for them, or they don't know how to pay for them. And we're talking about things that we need, like cleaning services, snow removal, pest extermination, all of those types of things, or they may not even realize that they need services to their home. Now, this list is by no means exhaustive. This is just to give you an idea of some red flags to look for, or some things that your incapable adult may be going through that you might not be able to see visually. But I can attest to this. Fun fact, I actually fall into this category. I have two loved ones, two incapable adults, my mom and my dad. And I can tell you that I personally have experienced absolutely every single point on this slide and more, right down to the pest extermination. So definitely, this is not exhaustive, but it definitely gives you a good idea of what an incapable adult may be going through. But before we discuss adult guardianship, less intrusive options must be considered. It is my job to talk to you about any other type of method of how to care for your loved one and how to make decisions for your loved one without actually obtaining adult guardianship. Now, the reason for this is because the government, the Office of the Public Guardian and Trustee, they do not give out guardianships casually. In fact, they would like you to know, and they would like you to treat it like it's the last possible resort. And that's because adult guardianship essentially means that that loved one, that incapable adult, will be giving up their rights, and you will be taking over for the responsibilities that they can no longer manage. So we need to look at some other options. So where do we begin? Well, we always have to start with power of attorney. What is power of attorney? Well, a power of attorney, or otherwise often referred to as a POA, is simply a legal document that lets you, the grantor, name someone to make decisions for you, and we call that person the attorney. So throughout this presentation, you're going to hear me say the word attorney a lot. I absolutely do not mean a lawyer or a paralegal or any kind of legal professional. It simply is that person that you decided to put on your legal document, that person that you trust and that you know, that you would one day maybe need to make decisions for you in the future. It's somebody that you pick out of your own volition and that you document on this legal document, this power of attorney. Now, I think a lot of people also think that powers of attorney or a power of attorney is kind of like a one-time blanket, one-size-fits-all type of document. Well, that's absolutely false. In fact, there's actually two types of power of attorney. And between the two of them, it's supposed to encompass essentially every facet of our life. So on the one hand, we have power of attorney of personal care. And on the other side, we've got power of attorney of property. Now, you can pick one person for both, a different person for each one, or multiple people for each one, but you must be mentally capable when creating these documents. And the definition of mentally capable is actually different depending on which document you are creating. So let's start by talking about power of attorney of personal care. What does it mean to be mentally capable to create a POA of personal care? Well, it means that you only have to check two mental boxes. You need to be able to understand whether the person that you're naming as your attorney, so that that attorney is the person that you wrote down as the person that you trust to make decisions for you one day, you understand that that person is truly concerned about how you live and how you're taken care of. And you understand that you may actually need this person one day to make decisions for you. Not too bad. That's not a lot to worry about. Now, some points to note about power of attorney of personal care. You are choosing a person that you trust to be your substitute decision maker, just in case you become mentally incapable one day in the future. Now, you also should pay attention to the word substitute decision maker. That's also a big one in this presentation. So this person that you picked, they will have the authority to make decisions for you about personal care. And that includes 6 areas, only 6 areas. And that is healthcare, housing, nutrition, clothing, hygiene, and safety. Now, you're going to hear me say those 6 things quite a few times throughout this presentation as well. Now, decisions about your medical treatments would include either agreeing or refusing treatments by any type of regulated healthcare professional. So that would be basically anyone who wears a white coat, a doctor, a dentist, a nurse, a physiotherapist, a registered massage therapist, basically anyone who has your health at their interest. They are the ones that they can make decisions for you on behalf. They can also help move you into long-term care facilities and make decisions regarding the assistance services that are required in long-term care. Now, the key to power of attorney of personal care is that this only takes effect if you're not mentally capable of making these decisions for yourself. So what that means is, so there's 6 areas. If you're perfectly capable of making 4 out of the 6 areas decisions for yourself, then you should. If you're able to make 5 and there's only 1 area that you need some help with, then you should be making those decisions in those 5 areas. Now, the example that I like to give is perhaps you're somebody who's very independent. You live alone. You wake up and every day you are absolutely fully capable of taking a shower, getting dressed, making yourself food, getting yourself ready for the day. But for whatever reason, your medication just really confuses you. You can't remember when you're supposed to take it or how much you're supposed to take or even why you're taking it sometimes or how often. So this would be when your attorney, so your friend that you designated as the person to make these decisions, if they saw that you were struggling in this area, they would literally take a look and think, how can I help them here? So they may come up with a way like perhaps getting little blister packs at the pharmacy so that you know how much medication you need to take. Or maybe they put up a big whiteboard with like a checklist on it for you to go through every day. Or maybe they call you every day and just say, hey, it's time to take your medication. There's lots of ways that your attorney can help you in that area. But because you're fully capable and you've shown that you're capable to wake up every day and get dressed and all those other things are just fine, well, they wouldn't intervene with that. They would only do the things that you would need help with. So again, your attorney can only make decisions that you're not capable of making. Now, I did put here at the bottom here, I think it's important information for you to know, your power of attorney document can also include a statement about who decides whether or not you're capable to make personal care decisions. This can be a healthcare practitioner. This can be your attorney. It could be your friend. But if you don't include the statement, then your attorney, so that person that's listed as your as the one that's going to make those decisions, then they are the one that's going to determine whether or not you need their help. So next, power of attorney of property. What does it mean to be mentally capable to create a power of attorney of property? Well, it's a lot riskier, and therefore there's a few extra boxes that need to be checked mentally in order to be considered mentally capable. The first one, you have to know what property you have and approximately how much it's worth. Number 2, You need to know if someone depends on you financially and what you do for them. 3, you know that as long as you're mentally capable, you can revoke or cancel your power of attorney really at any time. And 3, you understand the power that you're giving your attorney, the duties that they're allowed to do. And the clincher, you understand that if your attorney does a crappy job, or they're dishonest, or they just don't do a good job, well, you could lose your money. You could lose everything. So it is so important that you understand these 5 areas. And in particular, you need to really think about and really trust the person that you designate as your power of attorney of property. Now, some points to note about power of attorney of property is that this document lets your attorney, so again, the person that you designated, it lets your attorney deal with your property on your behalf. Now, property is another one of those words that they chose to use in this area that probably wasn't the best word. Property here includes so much more than just real estate. It includes things like your banking, signing checks, paying bills, buying or selling real estate, just buying regular goods and services like furniture. It actually includes so much of our daily routine procedures that we do on a regular basis as adults without even thinking about it. A power of attorney of property, another thing hugely important, can actually start working as soon as you sign it. So unlike a power of attorney of personal care, where essentially it only takes effect if you really need it, and like I mentioned with those 6 areas, if you're good in 4 of the areas, then you're still making those decisions there. No one is stepping in to help you until you need it. Well, a power of attorney for property starts working as soon as you sign it. And that means even if you are still completely mentally capable, your attorney can start managing your property. Now, I don't think a lot of people really realize, again, and this is with both documents, the power of attorney of personal care and power of attorney of property, people don't realize just how customizable these documents actually are. So for instance, a lot of people or knowledgeable people, people that research, would know that a power of attorney of property, there are certain things that you can do with it. You can limit how long it lasts. So if you're somebody who is regularly away for extended periods of time on vacation, or perhaps you own a home somewhere else in the world and you like to go there pretty often, you may have a power of attorney designated to somebody who takes care of your things while you're gone. But when you're there, that power of attorney is not valid. Another thing you can do is you can limit how long it lasts, or you can also make it so that only certain things are done within it. So if you want to sell your house, but you want nothing to do with the selling of the house, you can create a power of attorney that designates somebody to make all those decisions for you. And then once the house is sold, or whatever the implications are on that document are complete, then that power of attorney document is expired. So there's lots of things that you can do. It's very customizable, and people really need to understand and take advantage of that. Now, the last point that I put in here that I think is so important, again, it goes along with the whole customizable theme. If you want your power of attorney for property to only come into effect when you're mentally incapable, just like your power of attorney for personal care, well, then all you have to do is say so. You need to include a statement saying this. And while you're there, it's a good idea to pick whoever it is that you want to make that decision. So again, it doesn't have to be a healthcare practitioner. It doesn't have to be a formal capacity assessor. It can be your friend. It could just be somebody that you trust. It can be your attorney. But if you put a statement in there saying that you have to be deemed mentally incapable, but you did not say who that person was going to be, then your attorney, so again, the person that you listed as the person making those decisions for you, then they will actually have to hire a formal capacity assessor to do an assessment, a capacity assessment on you to determine whether or not you're capable of making those decisions. And they're expensive. The bottom line about POAs, if your loved one is mentally capable, and that means that they can check off those appropriate mental boxes, if they're mentally capable to create their powers of attorney, then they absolutely should, even if it's just one and not both. Power of attorneys are the fastest, easiest, and cheapest route to go to ensure that our loved ones are protected should something go wrong. But if your loved one does not have the mental capacity, and that means they can't check off those boxes at the time of creating the documents, and the reason why I put that in there is because some people, when you're dealing with an incapable adult that was once capable, they may think that, well, it's okay to try to create this document because my mom would have wanted this, or my grandma told me that, this is what she would want on it. Well, that's just not the case. You have to be mentally capable at the time of creating the documents, or the documents simply will not be valid if you create them on your own, or the lawyer simply just will not complete the process if you show up, because they are looking for those mental boxes to be checked too as they go along. And if they see that something's just not adding up, well, unfortunately, the process will not be completed. Now, on that note, I did put a little note at the bottom here. Lawyers can be expensive, but having your power of attorney documents created by a lawyer, particularly when you're dealing with somebody who has a disability, well, it adds credibility. And what that means is that there is less of a chance that your document will be challenged. And I'm talking about places like banks or insurance companies or investment companies. If they see that you have like a do-it-yourself type document, even though they're completely valid when they're witnessed properly, unfortunately, often they will challenge you on it and ask you to produce more information, or ask you to come up with another document, or ask you to fill out one of their documents. It can be quite a lengthy process. So you're better off, in my opinion, to have a lawyer create it so that maybe they won't challenge you. Perfect. So now we've made it. I know you're here today because you're representing a loved one that likely is not able to make a power of attorney and they're just not capable. So what are your options? Well, your option is adult guardianship. A guardian is someone who steps in to make decisions for the person who lacks capacity. So unlike power of attorneys, where you are choosing someone that you trust just in case you need them one day, a guardian is someone who knows you. They see a need, they see something's not right, you need help, you're not able to manage your property, you're not able to manage your healthcare decisions. And they literally put their hand up and say, hey, this person needs help, and I want to be that person that helps them. Now, a guardian is very similar to a power of attorney. In fact, it's so similar, there's two of them. And in fact, they're so similar, they called them the same thing. We have a guardian of personal care and the guardian of property. They weren't that creative with the naming of things, that's for sure. So when we look at guardian of personal care, we see here that they have the legal authority to make decisions regarding those exact same 6 areas: healthcare, nutrition, shelter, clothing, hygiene, and safety. A guardian of personal care has all the same authorities that a power of attorney of personal care has. Now, switching over to the other side, the guardian of property. Well, the powers and duties of a guardian of property are actually set by law, and they're very specific about the duties and the powers. It comes out of the Substitute Decisions Act of 1992 and the regulations underneath that law. And some of the examples that they list that a guardian of property can do on someone's behalf: open and close bank accounts, redirect pensions and other income, apply for benefits or supplementary income that that person is entitled to, choose pension options, deal with investments, collect debts, pay bills, buy goods and services, start or defend lawsuits, lend, sell, store, or dispose of personal belongings, maintain or sell a house or a vehicle. A guardian of property can do almost anything in regards to someone's property except make a will on their behalf. So now you'll see here, we talked earlier about how power of attorney of property lists a number of things that we do on a regular basis. This is the exact same thing. So this is adulting at its best. We do this on a regular basis without even thinking about it, even though it is a challenge for an incapable adult. So how can I become a guardian? Well, there's actually two ways to become someone's guardian. The first way is through a judge in court, and the second way is through the Office of the Public Guardian and Trustee. We call that the PGT, and that's by application. So now if you've decided that, I'd like to go through a judge in court, well, the sky's the limits for you here. You can become a guardian of personal care, a guardian of property, or something that's called a guardian of the person. And what that is it's essentially the guardianship of personal care and guardian of property smushed together. There's also other things you could do when you're going through a judge in court. And that would be, you can, bring somebody else in with you, and you can customize your guardianship. So maybe you're doing a portion of it and the other person is doing another portion, or you can mix and match, or there's other things that you can do when you are dealing with an actual judge who's able to designate things. Now, number two, if you decide to go through the Office of the Public Guardian and Trustee, which is an application process, this is only for guardianship of property. You absolutely cannot get guardianship of personal care. You absolutely cannot get guardianship of the person. You can only apply for guardianship of property. And now often, like when I first started learning about this and started, wondering like, why only guardianship of property? Well, it became very clear to me that this opportunity, this application process is really more like a gift from the government. It is for families, for individuals that really wouldn't be looked at as, potentially taking advantage of a situation. So we're talking about parents of a child who just turned 18, who has a developmental disability. Essentially, those parents simply want to continue their parenting, and they're running into many difficulties, lots of red tape, because they don't have this piece of paper that says they can make decisions on behalf of their child. Who needs it? Or it's a married couple, and one of them has developed Alzheimer's, and the other person now has to look at, paying for things and potentially selling their home, or things of that nature that they may be stopped from gaining access to because they need the signature of their loved one, and their loved one's unable to do that now. So there are different reasons why people would like guardianship. The application process is truly supposed to be the no-brainer type application process, where essentially what I already said, parents who want to continue parenting, a married couple that wants to just continue caring for each other, something that makes sense and that wouldn't alarm the PGT when they look at it. Now, I did put a note here. It is possible to become someone's guardian of property without becoming their guardian of personal care, and vice versa. Not everyone needs to create both, and often guardianship of property is all that you need. I'll tell you why. So which guardianship option is right for me? Where am I going to put this? I'll put it down there. So we already talked about guardianship of personal care. That gives somebody the legal authority to make decisions regarding healthcare, nutrition, shelter, clothing, hygiene, and safety. This is only court awarded. We talked about guardianship of property, which has a whole list, plus so much more. Essentially, almost anything in regards to someone's property except make a will. And by the gift of the government, it is available through the application process through the PGT. Or we have something called the guardianship of the person. And this is a big one because it encompasses everything. It is both sides of the coin. It is the personal care, it is the property, it is everything squished together. The incapable adult will lose all their rights, and that guardian will be responsible for every facet of that incapable person's life, and they'll have to account for it. So they will have, if challenged or if asked, they would have to provide reasoning for the decisions that they've made for this incapable adult, all the way through the guardianship, really, and always make sure that they are very, very detailed and organized as to, again, the entire person's life and every decision made within it. So 3 interesting facts that no one really talks about, or maybe they don't talk enough about it, or maybe they just don't go into enough detail that these points really hit home for people. I had to make this a slide because this is such important information for you. Number 1, we've already talked about this. In Ontario, a guardian of personal care is responsible for healthcare, nutrition, clothing, shelter, safety, and hygiene. But did you know relatives like parents or spouses are often already the substitute decision maker for medical treatment decisions? And so do they really need to go to court for the extra authorities of nutrition, shelter, clothing, hygiene, and safety? I don't know. Number 2, under the Healthcare Consent Act, everyone in Ontario has an automatic substitute decision maker when it comes to medical treatment decisions we're incapable of making. I remember when I first heard this, I literally was like, what does this mean? How do they know who I want as my automatic substitute decision maker? Who came up with this? Like, where are they getting it from? I certainly didn't fill out a form or call anyone or go to the lawyer or tell my doctor. I've done nothing. So how do they know? What do they do when I'm in a situation where I can't make decisions for myself in a medical situation? What do they do? Well, there's a list. And it's a hierarchy. And this hierarchy is essentially the highest ranking family members. And if you're in a situation where medical treatment decisions need to be made for you because you're just not capable of making them, well, that healthcare practitioner will literally go down this list until they find somebody, a substitute that's available, capable, and willing to make decisions on your behalf. Do you want to see the list? I've got it right here. So this is the order. This is the substitute decision makers hierarchy of decision makers. You'll see here numbers 1, 2, and 3 are all legally appointed. So if a decision needs to be made, they're going to look for these top 3 things first. Number 1, a guardian. Trumps everybody, a guardian. Number 2, power of attorney. Number 3, a representative appointed by the Consent Capacity Board. And that is a tribunal that has very limited authorities. So they can sometimes designate things like this to it, but that's separate and not enough. So if your loved one, if you, if me, if we are in a situation where we can't make a decision on our behalf because we're just not capable, well, what does that medical practitioner do? Well, if numbers 1 through 3 are just simply not a thing, and we are here today because we're assuming our loved ones do not have these 3 things in place, well, they automatically jump through numbers 4 through 8. Does this person, do you, do I, have a spouse or a partner? Number 5, do we have a child or a parent? Number 6. Number 6 actually deals with minors who are incapable. So it would be a parent who actually has access rights to the child, to the minor. Number 7, does this person have a brother or a sister? And number 8, the best one yet, is there any other relative by blood, marriage, or adoption? Is there anyone that knows you at all? anyone that would step up to make that decision for you that they think that you would want on your behalf? Is there anyone? Can we find anyone? Because if not, then number 9, the PGT, the Office of the Public Guardian and Trustee, they will be called in to make those decisions for you if there is no one else. And I do understand that there are some people who maybe don't have family, or they're estranged from their family, or they've never had kids, or they never got married, or never had siblings. They do exist. And the public guardian and trustee will be called to make decisions on those people's behalf. But where do you stand on this list? So if the person you are here today for, if they're your child, like, would you be the one that's called? If this person that you are here for today is your spouse, would you be the one that's called? I think you probably would be. So 4 questions you need to ask yourself. Number 1, does your loved one's rights matter to you? Well, if they do, what do you absolutely need right now? Well, guardianship of property is probably all that you need. Number 2, do you have lots of money and lots of time? If yes, then maybe go the court route for full guardianship or for customized guardianship. But you need to make note of 4 very important points. Number 1, you will very likely need a lawyer to advocate for you. Paralegals are not an option for this particular court. Number 2, the paperwork involved is very extensive. It is well over 200 pages. Number 3, there is no set time limit for when your matter will be determined by a judge. So after you have your paperwork in place and you're ready to go see a judge, you might be looking at another 6 months or so. That's what I've been told. And number 4, the hardest point to swallow here, be prepared to spend possibly up to $25,000 in legal fees for full guardianship of your loved one. That is a number that I actually received from a lawyer in London a few months ago who was doing a webinar on guardianship and financial matters and that type of thing. Came right out and said $25,000. So I was quick to add that to my presentation because people need to realize this is big bucks. Number 3, will your decision to become guardian of property be contested by anyone? Is there family fighting? Well, if there is family fighting or somebody, somebody's going to stand up and say that you are not the right fit for this job, well, then the court route is recommended for full or even partial or custom guardianship for you. And the reason why that is because, again, the application process through the PGT, again, is supposed to be the no-brainer, smooth transition type guardianship application. You do have to list all of the incapable loved one's family, their contact information. You have to list there whether or not these particular family members are aware of the guardianship application, and you need to write whether or not they would oppose to it. And let me tell you, the PGT checks, they call, they look at everyone on that list. They want to make sure that you are there for the right reasons. So if there's someone on that list who you know will contest, or they think that they'll do a better job, you're better off just taking it to a judge and letting the judge designate who the right person is for the role. Number 4, is this a role you're already doing? What, if anything, will change? Well, if the personal care portion really isn't going to change, then guardianship of property is probably all that you need. So who can apply for statutory guardianship of property through the PGT? Well, I always tell my clients, let's start by taking the pre-qualifying quiz, which you can also find on my website, tbhlegal.ca. If you're here tonight because you have an adult child, there are 4 questions essentially that you need to answer yes to. Number 1, is the child 18 or almost 18? Because we absolutely cannot submit this application until they are an adult. Makes sense. Number 2, are you a relative or a family member to the adult child? Number 3, is the adult child living in Ontario, Canada? Because if they're not, unfortunately, you just listened to this entire presentation for no reason at all, because it only applies to incapable adults living in Ontario. Number 4, will the adult child be capable of participating in a capacity test, or at least not contest to it? The biggest factor here that I get asked is being nonverbal okay? Absolutely, it's okay. It just means that your assessment's probably going to go a little bit faster. But essentially, that is not a reason for the capacity test not to happen. The capacity test is a vital component to the application process. It is the only piece of evidence that you're providing that states that your incapable adult is in fact incapable. Now, if you're here tonight because you have a loved one who was once capable and they are now an incapable adult, you have 5 questions you need to answer yes to. Number 1, are you a relative or family member to the incapable adult? Number 2, are you sure they don't have a valid POA already in place? Number 3, this is where the family fighting kicks in. Are the relatives or family members of the incapable adult supportive of your application for guardianship? Because you will have to disclose that. Number 4, is the incapable adult living in Ontario, Canada? And we already talked about that. Number 5, will the incapable adult be able to participate in a capacity assessment, or at least not contest to one? And again, it's okay if your loved one is confused. It's okay if they're upset. It's okay if they, don't really participate because they are unsure. They don't know the person that's in the room. With dementia, with Alzheimer's, with those conditions that are associated with incapable adults that you would want guardianship for, the capacity assessor knows this. What's not okay is to not have the test done. They need to be in that seat and they need to be in the room with the capacity assessor, or we simply wouldn't be able to complete the application. Because again, as I mentioned already, it is a vital component to the application process. So yay, I passed the quiz. What's next? Well, if you've decided you're interested in obtaining guardianship of the person, so that means both sides, the personal care and the property squished together, then you have 2 options. Number 1, you can start with statutory guardianship of property through the PGT, as you probably need this right away. And then you can proceed with guardianship of personal care with a health lawyer. This would actually make things substantially cheaper for you if one side is already complete. Number 2, you can proceed immediately with guardianship of the person with a health lawyer who practices in this area. But you must be mindful of the 4 points that I've already told you about in the previous slide. Now, if you're interested in applying for statutory guardianship of property through the PGT, and you'd like to use TBH Legal for this, well, we actually have a 10-step process that we use, and you've already done the first step, which is taking the pre-qualifying quiz. The next steps are be mindful of the fees that are required and that may be required. And I have those listed on my website as well, tbhlegal.ca. Now, everyone's situation is different, and that is why I have fees that are non-negotiable and fees that you might be asked for and you might not be asked for, depending on your situation. In particular, if you're dealing with an incapable adult who has a ton of assets and they're worth like so much money and they have, businesses, lots of money in the bank, that's when things get a little bit pricier, and not even all that much, but they do get pricier because you may have to take a surety bond on your on the incapable person's assets. But that, again, would be mentioned to you later. But it is something you need to be aware of, just in case you do have a millionaire on your hands that you will be taking over the property management of. Number 3, contact TBH Legal. Obviously, lots of ways to contact me: email, phone, the contact us page on TBH Legal. I'm very easy to get a hold of. Number 4, fill out the forms to become a client, just like you would for any other professional. you will be sent, number 5, homework. I will send you through an email 2 different pieces of homework. And honestly, I break it down so much. I take out all the legalese. You will be providing me with information that I will use to populate your management plan, to populate all the forms and assessment requirements for you. And I use your homework to use it to populate it. Number 6, you pick the capacity assessor. I will give you a list full of people, full of options, and anything I know about them. So if I know, well, the number one thing I ask them is, how much do you cost? They are all different in their fees, even though they're all doing the same thing. And they all do things a little bit differently. So it's important that you pick the capacity assessor that's right for you. And also, there are virtual options. So I have recorded on this document, based on your area, who offers virtual options instead of having to do it in person. So then we'll complete the application process. You'll sign it with an actual pen and we'll ship it off to the PGT. And then we wait either for the guardianship document to arrive, if it's pretty much a very simple application, like an 18-year-old who has very limited assets, or the PGT, if you know you're dealing with somebody who has lots of property, then be prepared to be contacted by the PGT to perhaps ask you for some more information on yourself, your identification, that type of thing. So we made it to the end. Thank you so much for being here with me tonight. I realize that I have supplied you with probably more information than you thought you would be getting yourself into tonight, but I really do feel that every piece that I presented goes hand in hand with each other, and really none of it could be left out, in my opinion. So it's a great opportunity for you right now. If you have any questions, feel free to ask. I do ask, though, that you try to refrain from really mentioning anything too personal, because I won't be giving out any actual advice this evening. But general questions are definitely welcome, and you are certainly welcome to email me for like some private advice as well, or to get started if you'd like. So,
thank you so much,
I'm all
Rachel,
done.
for this informative and wonderful presentation. And we've got a question here from Kathy. So we need the capacity assessment with young adult?
Yes. If you're going through the application process through the PGT, there is no way out. It doesn't matter if you have a diagnosis in some other format. It doesn't matter if you got the educational assessment or the DSO assessment. The capacity assessment is the only acceptable method for the application process of the PGT. Because believe me, I've tried. I have asked. I have knocked on every door to say, is there any other way around this? And unfortunately, there is no other way.
So I have a question, actually. Is there any government fees for that process?
Like benefit fees?
No. Governmental fees. Do we need to pay the government of Ontario to issue any kind of documents or certificate?
So the fee, there is so all my fees, or all the fees that may be required or that are required, are listed on my website. But essentially, in order to submit the application, and I'm assuming you're talking about the application process.
Yes.
They don't always ask for it, but there is an application fee. It's approximately $400 or so. But it's after you're approved for guardianship, and then sometimes they ask and sometimes they don't. So be prepared to spend it for sure, but don't ask about it and don't supply it in advance. We just wait and see what they say.
Yep. So we've got another question from Katie. So how long does it take?
So depending on how complicated the individual is. So if they are freshly 18 or a young adult with very little assets, My quickest guardianship approval was 6 weeks. It was honestly so exciting for me because I was like, yes, we perfected it. We know what we're doing. We know what they want to see and what the PGT is looking for. We had the guardianship piece of paper in our hands in 6 weeks. Now, if you are here because you have an incapable adult that was once capable and they have, like, honestly, we're talking about 70, 80, 90-year-old people who didn't have a valid power of attorney put in place before they became incapable. They could have millions in assets. So those types of situations, the PGT will be scrutinizing a little closer, because if that applicant has anything to gain, because essentially they will be given the complete rights to this person's property. If there's any reason to question that person, that applicant, they're going to look through it a little closer. I believe the maximum is 6 months. When I've talked to the PGT in numerous times, they've always told me 4 to 6 months, 4 to 6 months. And the more complicated, the closer to the 6-month mark. Also, the other thing too is multiple people can apply jointly through the application process. And it's not customizable. So you can't say, you're going to do this half and I'm going to do this half. You both, or the 3 of you, or the 4 of you, or the 6 of you, you all have to make these decisions as one person. And those applications can take a little longer too, because they are vetting each of those applicants, number one. And number two, they don't really like those too much. So they might come back and say, hey, like, can you eliminate a few of these people? Because there's too many cooks in the kitchen. And we don't necessarily believe that all 6 of you will sit down and make every decision for that incapable adult. So it may prolong the process a little bit, but straightforward, simple application processes that really aren't going to question the PGT. 4 to 6 months in general, but could be as quick as 6 weeks because I've seen it.
Thank you so much, Bridget, for this. I would like to thank you so much on behalf of RRAI for this wonderful and informative presentation. And again, if you have any specific question related to a certain case, please feel free to reach out to Rachel Merucci. Thank you so much for being here tonight with us, Rachel.
Oh, you're so welcome. Thank you for having me. It was an absolute pleasure on my behalf. And I really hope that the viewers, the people who tuned in, I hope that everyone walked away with something either personally for themselves or for their loved ones that they're here representing today.
Thank you so much, and see you hopefully in another event with the Rights and Responsibilities Awareness Initiative.
Okay. Thank you, everyone. Good night.
Night.